Title II. Elective Officials. Chapter 1. Qualifications and Election. Section 39. Qualifications. A. An elective local official must be a citizen of the Philippines, a registered voter in the barangay, municipality, city, or province, or, in the case of a member of the provincial board, city council, or municipal council, the district where he intends to be elected, a resident therein for at least 1 year immediately preceding the day of the election, and able to read and write Filipino, or any other local language or dialect. B. Candidates for the position of governor, vice governor, or member of the provincial board, or mayor, vice mayor, or member of the city council of highly urbanized cities must be at least 23 years of age on election day. C. Candidates for the position of mayor or vice mayor of independent component cities, or municipalities must be at least 21 years of age on election day. D. Candidates for the position of member of the city council or municipal council must be at least 18 years of age on election day. E. Candidates for the position of punong barangay or member of the barangay council must be at least 18 years of age on election day. F. Candidates for the SK must be at least 15 years of age, but not more than 21 years of age on election day. Section 40. Disqualifications. The following persons are disqualified from running for any elective local position. A. Those sentenced by final judgment, for an offense involving moral turpitude, or for an offense punishable by 1 year or more of imprisonment, within 2 years after serving sentence. B. Those removed from office, as a result of an administrative case. C. Those convicted by final judgment, for violating the oath of allegiance to the Republic. D. Those with dual citizenship. E. Fugitives from justice in criminal or non-political cases, here or abroad. F. Permanent residents in a foreign country, or those who have acquired the right to reside abroad, and continue to avail of the same right after the effectivity of this code, and G. The insane or feeble-minded. Section 41. Manner of election. A. The governor, vice governor, city mayor, city vice mayor, municipal vice mayor, and barangay chairman, shall be elected at large in their respective units, by the qualified voters therein. However, the SK chairman for each barangay, shall be elected by the registered voters of the Katipunan ng Kabataan, as provided in this code. B. The regular members of the provincial board, city council, and municipal council shall be elected by district as follows. First and second class provinces shall have 10 regular members, third and fourth class provinces, 8. And fifth and sixth class provinces, 6, provided that in provinces having more than 5 legislative districts, each district shall have 2 provincial board members, without prejudice to the provisions of Section 2 of Republic Act No. 6637. Barangay council members shall be elected at large. The presidents of the leagues of Sanggunian and members of component cities and municipalities, shall serve as ex officio members of the provincial board concerned. The presidents of the Liga ng mga Barangay and the SK Federation elected by their respective chapters, as provided in this code, shall serve as ex officio members of the provincial board, city council, and municipal council. C. In addition thereto, there shall be 1 sectoral representative from the women, 1 from the workers, and 1 from any of the following sectors: the urban poor, indigenous cultural communities, disabled persons, or any other sector as may be determined by the Sangguniang concerned within 90 days, prior to the holding of the next local elections, as may be provided for by law. The COMELEC shall promulgate the rules and regulations, to effectively provide for the election of such sectoral representatives. Section 42. Date of election. Unless otherwise provided by law, the elections for local officials shall be held every 3 years on the second Monday of May. Section 43. Term of Office. A. The term of office of all elective officials elected, after the effectivity of this code shall be 3 years, starting from noon of June 30, 1992, or such date as may be provided for by law, except that of elective barangay officials and members of the SK, provided that all local officials first elected during the local elections immediately following the ratification of the 1987 Constitution, shall serve until noon of June 30, 1992. B. No local elective official shall serve for more than 3 consecutive terms in the same position. Voluntary renunciation of the office, for any length of time shall not be considered as an interruption in the continuity of service for the full term for which the elective official concerned was elected. C. The term of barangay officials and members of the SK shall be for 5 years, which shall begin after the regular election of barangay officials on the second Monday of May 1997, provided that the SK members who were elected in the May 1996 elections shall serve until the next regular election of barangay officials. Chapter 2. Vacancies and Succession. Section 44. Permanent vacancies in the offices of the Governor, Vice Governor, Mayor, and Vice Mayor. A. If a permanent vacancy occurs, in the office of the Governor or Mayor, the Vice Governor or Vice Mayor concerned, shall become the Governor or Mayor. If a permanent vacancy occurs in the offices of the Governor, Vice Governor, Mayor, or Vice Mayor, the highest ranking Sanggunian member or, in case of his permanent inability, the second highest ranking Sanggunian member, shall become the Governor, Vice Governor, Mayor or Vice Mayor, as the case may be. Subsequent vacancies in the said office, shall be filled automatically by the other Sanggunian members according to their ranking as defined herein. B. If a permanent vacancy occurs in the office of the Punong Barangay, the highest ranking Barangay Council member or, in case of his permanent inability, the second highest ranking Sanggunian member, shall become the Barangay Chairman. C. A tie between or among the highest ranking Sanggunian members, shall be resolved by the drawing of lots. D. The successors as defined herein, shall serve only the unexpired terms of their predecessors. For purposes of this chapter, a permanent vacancy arises, when an elective local official fills a higher vacant office, refuses to assume office, fails to qualify, dies, is removed from office, voluntarily resigns, or is otherwise permanently incapacitated to discharge the functions of his office. For purposes of succession as provided in this chapter, ranking in the Sanggunian shall be determined, on the basis of the proportion of votes obtained by each winning candidate, to the total number of registered voters in each district in the immediately preceding local election. Section 45. Permanent vacancies in the Sanggunian. A. Permanent vacancies in the Sanggunian, where automatic succession provided above do not apply, shall be filled by appointment in the following manner. 1. The President. Through the Executive Secretary, in the case of the Provincial Board and the City Council of highly urbanized cities and independent component cities. 2. The Governor. In the case of the City Council of component cities and the Municipal Council. 3. The City or Municipal Mayor. In the case of Barangay Council, upon recommendation of the Barangay Council concerned. B. Except for the Barangay Council, only the nominee of the political party under which the Sanggunian member concerned had been elected, and whose elevation to the position next higher in rank created the last vacancy in the Sanggunian shall be appointed in the manner hereinabove provided. The appointee shall come from the same political party as that of the Sanggunian member who caused the vacancy, and shall serve the unexpired term of the vacant office. In the appointment herein mentioned, a nomination and a certificate of membership of the appointee from the highest official of the political party concerned, are conditions sine qua non, and any appointment without such nomination and certification, shall be null and void ab initio, and shall be a ground for administrative action against the official responsible therefor. C. In case the permanent vacancy is caused by a Sanggunian member, who does not belong to any political party, the local chief executive shall, upon recommendation of the Sangguniang concerned, appoint a qualified person to fill the vacancy. D. In case of vacancy in the representation of the youth, and the barangay in the Sanggunian, said vacancy shall be filled automatically, by the official next in rank of the organization concerned. Section 46. Temporary vacancy in the office of the local chief executive. A. When the governor, city or municipal mayor, or barangay chairman is temporarily incapacitated, to perform his duties for physical or legal reasons such as, but not limited to, leave of absence, travel abroad, and suspension from office, the vice governor, city or municipal vice mayor, or the highest ranking barangay council member, shall automatically exercise the powers, and perform the duties and functions of the local chief executive concerned. Except the power to appoint, suspend, or dismiss employees, which can only be exercised, if the period of temporary incapacity exceeds 30 working days. B. Said temporary incapacity, shall terminate, upon submission to the appropriate Sanggunian of a written declaration by the local chief executive concerned that he has reported back to office. In cases where the temporary incapacity is due to legal causes, the local chief executive concerned, shall also submit necessary documents showing that said legal causes no longer exist. C. When the incumbent local chief executive is traveling within the country, but outside his territorial jurisdiction for a period not exceeding 3 consecutive days, he may designate in writing the officer in charge of the said office. Such authorization shall specify the powers and functions, that the local official concerned shall exercise, in the absence of the local chief executive, except the power to appoint, suspend, or dismiss employees. D. In the event, however, that the local chief executive concerned fails, or refuses to issue such authorization, the vice governor, the city or municipal vice mayor, or the highest ranking barangay council member, as the case may be, shall have the right to assume the powers, duties, and functions of the said office on the 4th day of absence of the said local chief executive, subject to the limitations provided in subsection C hereof. E. Except as provided above, the local chief executive, shall in no case authorize any local official to assume the powers, duties, and functions of the office, other than the vice governor, the city or municipal vice mayor, or the highest ranking barangay council member, as the case may be. Section 47. Approval of leaves of absence. A. Leaves of absence of local elective officials shall be approved as follows. 1. Leaves of absence of the governor and the mayor of a highly urbanized city or an independent component city shall be approved by the president or his duly authorized representative. 2. Leaves of absence of vice governor or a city or municipal vice mayor shall be approved by the local chief executive concerned, provided that the leaves of absence of the members of the Sanggunian and its employees shall be approved by the vice governor or city or municipal vice mayor concerned. 3. Leaves of absence of the component city or municipal mayor shall be approved by the governor, and 4. Leaves of absence of a barangay chairman shall be approved by the city or municipal mayor, provided that leaves of absence of barangay council members shall be approved by the barangay chairman. B. Whenever the application for leave of absence hereinabove specified is not acted upon within 5 working days after receipt thereof, the application for leave of absence shall be deemed approved. Chapter 3. Local Legislation. Section 48. Local Legislative Power. Local legislative power shall be exercised by the provincial board for the province, the city council for the city, the municipal council for the municipality, and the barangay council for the barangay. Section 49. Presiding Officer. A. The Vice Governor shall be the presiding officer of the Provincial Board, the City Vice Mayor, of the City Council, the Municipal Vice Mayor of the Municipal Council, and the Barangay Chairman, of the Barangay Council. The presiding officer shall vote only to break a tie. B. In the event of the inability of the regular presiding officer to preside at a Sanggunian session, the members present and constituting a quorum, shall elect from among themselves a temporary presiding officer. He shall certify, within 10 days from the passage of ordinances enacted, and resolutions adopted by the Sanggunian in the session, over which he temporarily presided. Section 50. Internal Rules of Procedure. A. On the first regular session following the election of its members, and within 90 days thereafter, the Sangguniang concerned, shall adopt or update its existing rules of procedure. B. The rules of procedure shall provided for the following. 1. The organization of the Sangguniang, and the election of its officers, as well as the creation of standing committees which shall include, but shall not be limited to, the Committees on Appropriations, Women and Family, Human Rights, Youth and Sports Development, Environmental Protection, and Cooperatives, the general jurisdiction of each committee, and the election of the chairman and members of each committee. 2. The order and calendar of business for each session. 3. The legislative process. 4. The parliamentary procedures, which include the conduct of members during sessions. 5. The discipline of members for disorderly behavior, and absences without justifiable cause for 4 consecutive sessions, for which they may be censured, reprimanded, or excluded from the session, suspended for not more than 60 days, or expelled. Provided that the penalty of suspension or expulsion shall require the concurrence of at least 2/3 vote of all the Sangguniang members. Provided further that a member convicted by final judgment to imprisonment of at least 1 year, for any crime involving moral turpitude, shall be automatically expelled from the Sangguniang, and 6. Such other rules as the Sangguniang may adopt. Section 51. Full disclosure of financial and business interests of Sangguniang members. A. Every Sangguniang member shall, upon assumption to office, make a full disclosure of his business and financial interests. He shall also disclose any business, financial, or professional relationship, or any relation by affinity or consanguinity within the 4th civil degree, which he may have with any person, firm, or entity affected by any ordinance or resolution, under consideration by the Sangguniang of which he is a member, which relationship may result in conflict of interest. Such relationship shall include 1. Ownership of stock or capital, or investment, in the entity or firm, to which the ordinance or resolution may apply, and 2. Contracts or agreements with any person or entity, which the ordinance or resolution under consideration may affect. In the absence of a specific constitutional or statutory provision applicable to this situation, conflict of interest refers in general, to one where it may be reasonably deduced, that a member of a Sangguniang may not act in the public interest due to some private, pecuniary, or other personal considerations, that may tend to affect his judgment, to the prejudice of the service, or the public. B. The disclosure required under this Act, shall be made in writing, and submitted to the Secretary of the Sangguniang or the Secretary of the Committee of which he is a member. The disclosure, shall in all cases, form part of the record of the proceedings, and shall be made in the following manner. 1. Disclosure shall be made before the member participates in the deliberations on the ordinance or resolution under consideration, provided that, if the member did not participate during the deliberations, the disclosure shall be made before voting on the ordinance or resolution on second and third readings, and 2. Disclosure shall be made, when a member takes a position, or makes a privileged speech on a matter that may affect the business interest, financial connection, or professional relationship described herein. Section 52. Sessions. A. On the first day of the session immediately following the election of its members, the Sanggunian shall, by resolution, fix the day, time, and place of its regular sessions. The minimum number of regular sessions shall be once a week for the Provincial Board, City Council, and Municipal Council, and twice a month for the Barangay Council. B. When public interest so demands, special sessions may be called by the local chief executive, or by a majority of the members of the Sanggunian. C. All Sanggunian sessions shall be open to the public, unless a closed-door session is ordered, by an affirmative vote of majority of the members present, there being a quorum, in the public interest or for reasons of security, decency, or morality. No two sessions, regular or special, may be held in a single day. D. In the case of special sessions of the Sanggunian, a written notice to the members shall be served personally at the member's usual place of residence at least 24 hours before the special session is held. Unless otherwise concurred in by 2/3 vote of the Sanggunian members present, there being a quorum, no other matters may be considered at a special session, except those stated in the notice. E. Each Sanggunian shall keep a journal and record of its proceedings, which may be published upon resolution of the Sanggunian concerned. Section 53. Quorum. A. A majority of all the members of the Sanggunian, who have been elected and qualified, shall constitute a quorum to transact official business. Should a question of quorum be raised during a session, the presiding officer shall immediately proceed to call the roll of the members, and thereafter announce the results. B. Where there is no quorum, the presiding officer may declare a recess, until such time as a quorum is constituted, or a majority of the members present may adjourn from day to day, and may compel the immediate attendance of any member absent without justifiable cause, by designating a member of the Sanggunian, to be assisted by a member or members of the police force assigned in the territorial jurisdiction of the local government unit concerned, to arrest the absent member, and present him at the session. C. If there is still no quorum despite the enforcement of the immediately preceding subsection, no business shall be transacted. The presiding officer, upon proper motion duly approved by the members present, shall then declare the session adjourned for lack of quorum. Section 54. Approval of Ordinances. A. Every ordinance enacted by the Provincial Board, City Council or Municipal Council shall be presented to the Provincial Governor, or City or Municipal Mayor, as the case may be. If the local chief executive concerned approves the same, he shall affix his signature on each and every page thereof, otherwise, he shall veto it and return the same with his objections to the Sanggunian, which may proceed to reconsider the same. The Sanggunian concerned may override the veto of the local chief executive by 2/3 vote of all its members, thereby making the ordinance or resolution effective, for all legal intents and purposes. B. The veto shall be communicated by the local chief executive concerned to the Sanggunian, within 15 days in the case of a province, and 10 days in the case of a city or a municipality, otherwise, the ordinance shall be deemed approved, as if he had signed it. C. Ordinances enacted by the Barangay Council shall, upon approval by the majority of all its members, be signed by the Barangay Chairman. Section 55. Veto power of the local chief executive. A. The local chief executive may veto any ordinance of the Provincial Board, City Council or Municipal Council on the ground that it is ultra vires, or prejudicial to the public welfare, stating his reasons therefor in writing. B. The local chief executive, except the Barangay Chairman, shall have the power to veto any particular item or items of an appropriations ordinance, an ordinance or resolution adopting a local development plan and public investment program, or an ordinance directing the payment of money or creating liability. In such a case, the veto shall not affect the item or items which are not objected to. The vetoed item or items shall not take effect unless the Sanggunian overrides the veto in the manner herein provided, otherwise, the item or items in the appropriations ordinance of the previous year corresponding to those vetoed, if any, shall be deemed reenacted. C. The local chief executive may veto an ordinance or resolution only once. The Sangguniang may override the veto of the local chief executive by 2/3 vote of all its members, thereby making the ordinance effective, even without the approval of the local chief executive concerned. Section 56. Review of component city and municipal ordinances or resolutions by the Provincial Board. A. Within 3 days after approval, the Secretary to the City Council or Municipal Council shall forward to the Provincial Board for review, copies of approved ordinances, and the resolutions approving the local development plans and public investment programs, formulated by the local development councils. B. Within 30 days after the receipt of copies of such ordinances and resolutions, the Provincial Board shall examine the documents, or transmit them to the Provincial Attorney, or if there be none, to the Provincial Prosecutor for prompt examination. The Provincial Attorney or Provincial Prosecutor shall, within a period of 10 days from receipt of the documents, inform the Provincial Board in writing of his comments or recommendations, which may be considered by the Provincial Board in making its decision. C. If the Provincial Board finds that such an ordinance or resolution is beyond the power conferred upon the City Council or Municipal Council concerned, it shall declare such ordinance or resolution invalid, in whole, or in part. The Provincial Board shall enter its action in the minutes, and shall advise the corresponding city or municipal authorities of the action it has taken. D. If no action has been taken by the Provincial Board within 30 days after submission of such an ordinance or resolution, the same shall be presumed consistent with law, and therefore valid. Section 57. Review of Barangay Ordinances by the City or Municipal Council. A. Within 10 days after its enactment, the Barangay Council shall furnish copies of all barangay ordinances to the City or Municipal Council concerned for review, as to whether the ordinance is consistent with law, and city or municipal ordinances. B. If the City or Municipal Council, as the case may be, fails to take action on barangay ordinances within 30 days from receipt thereof, the same shall be deemed approved. C. If the City or Municipal Council, as the case may be, finds the barangay ordinances inconsistent with law, or city or municipal ordinances, the Sangguniang concerned shall, within 30 days from receipt thereof, return the same with its comments and recommendations to the Barangay Council concerned for adjustment, amendment, or modification, in which case, the effectivity of the barangay ordinance is suspended, until such time as the revision called for is effected. Section 58. Enforcement of disapproved ordinances or resolutions. Any attempt to enforce any ordinance, or any resolution approving the local development plan and public investment program, after the disapproval thereof, shall be sufficient ground for the suspension or dismissal of the official or employee concerned. Section 59. Effectivity of ordinances or resolutions. A. Unless otherwise stated in the ordinance, or the resolution approving the local development plan and public investment program, the same shall take effect after 10 days from the date a copy thereof is posted, in a bulletin board at the entrance of the provincial capital or city, municipal, or barangay hall, as the case may be, and in at least 2 other conspicuous places in the local government unit concerned. B. The Secretary to the Sangguniang concerned, shall cause the posting of an ordinance or resolution, in the bulletin board at the entrance of the provincial capital and the city, municipal, or barangay hall in at least 2 conspicuous places in the local government unit concerned, not later than 5 days after approval thereof. The text of the ordinance or resolution, shall be disseminated and posted in Filipino or English, and in the language or dialect understood by the majority of the people, in the local government unit concerned, and the Secretary to the Sangguniang shall record such fact in a book kept for the purpose, stating the dates of approval and posting. C. The gist of all ordinances with penal sanctions, shall be published in a newspaper of general circulation within the province, where the local legislative body concerned belongs. In the absence of any newspaper of general circulation within the province, posting of such ordinances shall be made, in all municipalities and cities of the province where the Sanggunian of origin is situated. D. In the case of highly urbanized and independent component cities, the main features of the ordinance or resolution duly enacted or adopted shall, in addition to being posted, be published once in a local newspaper of general circulation within the city, provided, that in the absence thereof, the ordinance or resolution shall be published in any newspaper of general circulation. Chapter 4. Disciplinary Actions. Section 60. Grounds for disciplinary actions. An elective local official may be disciplined, suspended, or removed from office on any of the following grounds. A. Disloyalty to the Republic of the Philippines. B. Culpable violation of the Constitution. C. Dishonesty, oppression, misconduct in office, gross negligence, or dereliction of duty. D. Commission of any offense involving moral turpitude, or an offense punishable by at least prisión mayor. E. Abuse of authority. F. Unauthorized absence for 15 consecutive working days, except in the case of members of the Provincial Board, City Council, Municipal Council, and Barangay Council. G. Application for, or acquisition of, foreign citizenship or residence or the status of an immigrant of another country, and H. Such other grounds as may be provided in this code and other laws. An elective local official may be removed from office on the grounds enumerated above by order of the proper court. Section 61. Form and filing of administrative complaints. A verified complaint against any erring local elective official, shall be prepared as follows. A. A complaint against any elective official of a province, a highly urbanized city, an independent component city or component city shall be filed before the office of the President. B. A complaint against any elective official of a municipality, shall be filed before the Provincial Board whose decision may be appealed to the office of the President, and C. A complaint against any elective barangay official, shall be filed before the city or municipal council concerned whose decision shall be final and executory. Section 62. Notice of hearing. A. Within 7 days after the administrative complaint is filed, the office of the President or the Sanggunian concerned, as the case may be, shall require the respondent to submit his verified answer, within 15 days from receipt thereof, and commence the investigation of the case within 10 days after receipt of such answer of the respondent. B. When the respondent is an elective official of a province or highly urbanized city, such hearing and investigation shall be conducted in the place, where he renders or holds office. For all other local elective officials, the venue shall be the place where the Sangguniang concerned is located. C. However, no investigation shall be held within 90 days immediately prior to any local election, and no preventive suspension shall be imposed within the said period. If preventive suspension has been imposed prior to the 90-day period immediately preceding local election, it shall be deemed automatically lifted, upon the start of aforesaid period. Section 63. Preventive Suspension. A. Preventive suspension may be imposed 1. By the President, if the respondent is an elective official of a province, a highly urbanized or an independent component city. 2. By the Governor, if the respondent is an elective official of a component city or municipality, or 3. By the Mayor, if the respondent is an elective official of the barangay. B. Preventive suspension may be imposed at any time after the issues are joined, when the evidence of guilt is strong, and given the gravity of the offense, there is great probability that the continuance in office of the respondent could influence the witnesses, or pose a threat to the safety and integrity of the records and other evidence, provided that Any single preventive suspension of local elective officials shall not extend beyond 60 days, provided further that in the event that several administrative cases are filed against an elective official, he cannot be preventively suspended for more than 90 days within a single year on the same ground or grounds existing and known at the time of the first suspension. C. Upon expiration of the preventive suspension, the suspended elective official shall be deemed reinstated in office, without prejudice to the continuation of the proceedings against him, which shall be terminated within 120 days, from the time he was formally notified of the case against him. However, if the delay in the proceedings of the case is due to his fault, neglect, or request, other than the appeal duly filed, the duration of such delay shall not be counted in computing the time of termination of the case. D. Any abuse of the exercise of the power of preventive suspension shall be penalized as abuse of authority. Section 64. Salary of Respondent Pending Suspension. The respondent official preventively suspended from office shall receive no salary or compensation during such suspension, but upon subsequent exoneration and reinstatement, he shall be paid full salary or compensation including such emoluments accruing during such suspension. Section 65. Rights of Respondent. The respondent shall be accorded full opportunity to appear and defend himself in person or by counsel, to confront and cross-examine the witnesses against him, and to require the attendance of witnesses and the production of documentary evidence in his favor, through the compulsory process of subpoena, or subpoena duces tecum. Section 66. Form and Notice of Decision. A. The investigation of the case shall be terminated within 90 days from the start thereof. Within 30 days after the end of the investigation, the office of the President or the Sangguniang concerned shall render a decision in writing, stating clearly and distinctly the facts and the reasons for such decision. Copies of said decision shall immediately be furnished the respondent and all interested parties. B. The penalty of suspension shall not exceed the unexpired term of the respondent, or a period of 6 months for every administrative offense, nor shall said penalty be a bar to the candidacy of the respondent so suspended, as long as he meets the qualifications required for the office. C. The penalty of removal from office as a result of an administrative investigation shall be considered a bar to the candidacy of the respondent for any elective position. Section 67. Administrative Appeals. Decisions in administrative cases may, within 30 days from receipt thereof, be appealed to the following. A. The Provincial Board, in the case of decisions of the City Council of Component Cities and the Municipal Council, and B. The Office of the President, in the case of decisions of the Provincial Board and the City Council of Highly Urbanized Cities and Independent Component Cities. Decisions of the Office of the President shall be final and executory. Section 68. Execution pending appeal. An appeal shall not prevent a decision from becoming final or executory. The respondent shall be considered as having been placed under preventive suspension during the pendency of an appeal, in the event he wins such appeal. In the event the appeal results in an exoneration, he shall be paid his salary, and such other emoluments during the pendency of the appeal. Chapter 5. Recall. Section 69. By whom exercised. The power of recall, for loss of confidence, shall be exercised by the registered voters of a local government unit, to which the local elective official subject to such recall belongs. Section 70. Initiation of the recall process. A. The recall of any elective provincial, city, municipal or barangay official, shall be commenced by a petition of a registered voter in the local government unit concerned, and supported by the registered voters in the local government unit concerned, during the election in which the local official sought to be recalled was elected, subject to the following percentage requirements. 1. At least 25%, in the case of local government units with a voting population of not more than 20,000. 2. At least 20%, in the case of local government units with a voting population of at least 20,000, but not more than 75,000, provided that in no case shall the required petitioners be less than 5,000. 3. At least 15%, in the case of local government units with a voting population of at least 75,000, but not more than 300,000, provided however, that in no case shall the required number of petitioners be less than 15,000, and 4. At least 10% in the case of local government units with a voting population of over 300,000, provided however, that in no case shall the required petitioners be less than 45,000. B. The process of recall, shall be effected in accordance with the following procedure. 1. A written petition for recall, duly signed by the representatives of the petitioners, before the election registrar or his representative, shall be filed with the CUMLEC through its office in the local government unit concerned. 2. The petition to recall shall contain the following. A. The names and addresses of the petitioners, written in legible form and, their signatures. B. The barangay, city or municipality, local legislative district and the province, to which the petitioners belong. C. The name of the official sought to be recalled, and D. A brief narration of the reasons and justifications therefor. 3. The CUMLEC shall, within 15 days from the filing of the petition, certify to the sufficiency of the required number of signatures. Failure to obtain the required number of signatures, automatically nullifies the petition. 4. If the petition is found to be sufficient in form, the CUMLEC or its duly authorized representative shall, within 3 days from the issuance of the certification, provide the official sought to be recalled, a copy of the petition, cause its publication in a national newspaper of general circulation, and a newspaper of general circulation in the locality, once a week for 3 consecutive weeks at the expense of the petitioners, and at the same time post copies thereof in public and conspicuous places, for a period of not less than 10 days nor more than 20 days, for the purpose of allowing interested parties to examine, and verify the validity of the petition, and the authenticity of the signatures contained therein. 5. The CUMLEC or its duly authorized representative shall, upon issuance of certification, proceed independently with the verification and authentication of, the signatures of the petitioners and registered voters contained therein. Representatives of the petitioners, and the official sought to be recalled, shall be duly notified, and shall have the right to participate therein as mere observers. The filing of any challenge or protest, shall be allowed within the period provided in the immediately preceding paragraph, and shall be ruled upon with finality within 15 days from the date of filing of such protest or challenge. 6. Upon the lapse of the aforesaid period, the CUMLEC or its duly authorized representative, shall announce the acceptance of candidates to the position, and thereafter prepare the list of candidates, which shall include the name of the official sought to be recalled. Section 71. Election on recall. Upon the filing of a valid petition for recall, with the appropriate local office of the CUMLEC or its duly authorized representative, shall set the date of the election or recall, which shall not be later than 30 days upon the completion of the procedure outlined in the preceding article, in the case of the barangay, city or municipal officials, and 45 days in the case of provincial officials. The official sought to be recalled, shall automatically be considered as duly registered candidate or candidates to the pertinent positions and, like other candidates, shall be entitled to be voted upon. Section 72. Effectivity of recall. The recall of an elective local official, shall be effective only upon the election and proclamation of a successor, in the person of the candidate receiving the highest number of votes cast during the election on recall. Should the official sought to be recalled receive the highest number of votes, confidence in him is thereby affirmed, and he shall continue in office. Section 73. Prohibition from resignation. The elective local official sought to be recalled, shall not be allowed to resign while the recall process is in progress. Section 74. Limitations on recall. A. Any elective local official may be the subject of a recall election, only once during his term of office for loss of confidence. B. No recall shall take place within 1 year from the date of the official's assumption to office, or 1 year immediately preceding a regular local election. Section 75. Expenses incident to recall elections. All expenses incident to recall elections shall be borne by the Cumlec. For this purpose, there shall be included in the Annual General Appropriations Act, a contingency fund at the disposal of the Cumlec for the conduct of recall elections.